what's the hope in terms of the implementation challenges?
The returns are easy to be filed. You have to do a one-time investment in terms of seeking consent.
And the first step would be the data protection board. So how do you see as how soon is immediate, and when will we see this?
We've prepared the digital office, that platform and everything else for the data protection board has been prepared. We are ready to roll it out.
When will we see the sovereign or national large language model? Is it a new year gift?
Let's see. That is what we are keeping our fingers crossed.
Hello and welcome to a new episode of Digital Playbooks. I'm your host Sindhu Hariharan, and today is a special episode where we look at one of the significant policy shifts in the Indian digital ecosystem, the release of the Digital Personal Data Protection Rules. We have with us a person at the center of it all, the Secretary of the Ministry of Electronics and Information Technology, Mr. S Krishnan. We will learn from him about some of the important benefits that the DPDP rules can provide to the citizens, the responsibilities it plays on companies that collect personal data, and also some of the challenges that are likely in its implementation. Welcome to the show, sir, and thank you so much for joining us today. To start off with, I'd like to first understand about what's the larger motivation behind bringing out the DPDP Act and the rules for India. What are some of the benefits that you hope to see from it?
You see, I think the most important thing with this Digital Personal Data Protection Act is that it actually gives teeth to the judgment of the Supreme Court in the Puttaswamy case in terms of preserving privacy and establishing the right to privacy as one of the fundamental rights. And the way it was intended to be done was through the DPDP Act, which came out in August 2023. And naturally, to implement the Act, you need a detailed set of rules, which has now been brought out. And also, the Act has now been notified after an extensive period of consultation on the rules. And we use this period of consultation on the rules primarily also to build awareness about both the Act and the rules, because what we found was that even amongst many stakeholders who are likely to be directly affected by the rules,
Right.
There was often a lack of understanding on what exactly the rules implied, what it would mean to each one of them individually. All those were issues. And therefore, it was important that we found a way by which we could reach out to more of them, discuss with them. And we held extensively number of sessions in Delhi, across various cities. We went to Mumbai, we went to Bangalore, we went to Chennai, we went to Kolkata, we went to Guwahati. We went to a number of cities, had a number of interactions, people represented to us, different groups met us. So I think it was good exercise, both in terms of the back and forth, in terms of the views that we received, and based on which we did make modifications in different places. And in addition, we also ensured that we were able to give greater publicity and generate greater awareness about the rules themselves and the various provisions contained therein. So now I believe that what it does effectively is it gives a lot of authority and empowers, or in a sense, gives agency to individuals, each one of us. It could even be you and me, in terms of how we become the data principals, and the sharing of data is something that happens with our consent, and various other players cannot use the data in ways which they are not intended to be used.
Right, sir. So in that sense, is the hope here that will the collection of digital personal data by companies themselves should go down, or is the hope that people will only collect data of whatever they need, or it's just about safer handling of this data once collected? What would you like to see as the result?
You see, it is all of these in some ways. Number one, that people should be aware that their data is being harvested or collected. So it can't be done without their consent. So it is not unknowingly you're sharing a lot of information. So that is one very important element. The second important element is the principle of data minimization, saying only seek as much data as you need, and clearly specify the purpose for which you're collecting the data, so that we can make a judgment as to whether the data being asked for is in line with uh, what the requirement for the data is. It's like you go to a departmental store, promptly they'll ask you for your mobile number. They don't need it. I mean, the way the subtle message there is that the cash counter or the till will not open till you give the mobile number.
Yes.
That's the way they do it. But they don't really need it. And if you tell them, no, I'm sorry, I don't want my mobile number to be given, you just go ahead and bill, they do it. So, some of these are very subtle sort of ways in which the personally identifiable data gets collected. So a data minimization is another important principle. So the purpose has to be identified, which means, and then there is a data minimization requirement. And thereafter, there's a responsibility on behalf of the data fiduciary to actually ensure that the data is used only for the purpose for which it is meant. If there is a deviation from that, then there is remedy. And equally, if there's a breach, then again there is a remedy. So safekeeping of the data and using it for the intended purposes is also an important responsibility which is cast. So every stage of that process is controlled. And then also there's a right for the data principal to ask for their data to be removed, and in certain cases to remove the data automatically, because just because you were a customer once upon a time, it doesn't mean that the data is retained and you permanently keep getting messages and it keeps getting misused. To that extent also, the periodicity or the period for which you can retain the data, there are limitations which are placed through the act and the rules as to how long you can retain it.
Right. So, in that sense, a lot of accountability, a lot of responsibility on companies. And as you may already know, India is a land of these MSMEs, the smaller traders, small app developers, who are all collecting this digital data from all of us today. So, what's the hope in terms of the implementation challenges you foresee?
Which is why we've given 18 months, and which is why there was such a long period in which we consulted and built awareness around it. You see, the point is that in a digital system, we need to recognize that the weakest link can cause the issues. So to say that I'm in business, I want to use digital means, but I don't have the means to comply. And the compliance mechanism is all very simple. It's an entirely digital office. The returns are easy to be filed. You have to do a one-time investment in terms of seeking consent. I mean, that is the requirement. And in any case, if you collect anybody's data, I think you have a responsibility for handling it carefully. And to say that, I need to be exempted so that I can do whatever I want with the personal data I collect does not seem to be a fair proposition.
Right. So the 18 months timeline itself, I mean, how's the industry saying? I mean, we are all people who file our income tax returns on the last day. So in that sense,
See,
how
the
is
point
the
is they kept waiting, and then there's been 2 years already from they knew that the act was coming. It's been 2 years and more than 2 years now, and a further 18 months, I think, is a very liberal time frame. In fact, the minister has himself indicated that on a voluntary basis, if companies are willing to come forward, they would like to, at least for the bigger social media entities and others, implement it even earlier. And many of them have some of these provisions, so they should be able to handle it.
So, in your sense, some bit of work was done in the last 2 years. That's what's the industry saying.
Yeah, many people have been working on it. We have not heard anything adverse saying that we can't comply or it should not be implemented immediately.
Right. So, in terms of the consultation itself, I think 6,000 plus kind of inputs received and all of that we saw. So, what were they largely on? Have all those been addressed? You'd say the
There is,
concerns.
yeah, most of them. We're also putting out a summary on what the key concerns which were raised were, and you will see that in the public domain. Many of them were actually, some of them were more clarificatory in nature. Many of the issues which were raised were more clarificatory in nature in terms of understanding the provisions of the rules and the act. And the other thing, like you said, in terms of compliance, what we have done is it's more a principle based legislation. So we are not being very prescriptive. We are saying that you need to make an effort. So we are not even prescribing a format in which consent is to be taken, because then it becomes, routinized and box checking and box ticking and so on. And for a big company, the need for, the way they are collecting it, they may have to sort of, provide a more detailed format Smaller entities which are collecting a limited amount of data will probably have to could make do with a simpler format. So we've allowed for that flexibility. So all of those, I mean, so some of those questions, some people said, why can't you prescribe? So we explain why it can't be prescribed. So those kind of specific questions. Certain other queries. So there's a detailed summary we have put out on the kind of queries that were raised and the kind of ways in which they were responded to.
Oh, okay, right. And so globally, I mean, any there's also this comment that why didn't we go all the way to say something like a GDPR? So what was the
I
train of
think that
thought there to
I
go
think
as
the train of
stringent?
thought seems to be even in the EU to step back a little from the
Okay,
GDPR and how onerous those requirements are. So I think you also have to choose. Are you in favor of the MSMEs and others who will find it difficult to comply even with this? To then
right.
ask me saying, why didn't you go as far as the GDPR? I think there
No,
has
I
to be
just
some
want to
logic to
understand
this line of questioning.
the larger train of thought that was behind the government.
See, I mean,
They wanted to strike a
you see,
balance.
there are different people who have different views. I think the most important thing, and I think what has been appreciated
Mm,
very widely, has been that we have struck a balance in this legislation and also in the rules. We have struck a balance between an extreme laissez-faire position of let the companies collect whatever they feel like and do whatever they can or however they want to act on it, to a position where don't make it as onerous as the GDPR or something else, and keep it less implementation heavy while respecting the principle. And I think this is the key thing between us and even the GDPR, that we recognize the data principle. We recognize that that the ownership of the data lies with the individual, and we are giving them agency, which I think is a huge thing. So, and to
right.
that extent, it's in some ways more enlightened. And we've also learned from their experience and what needs to be done there. So I think everyone believes we have struck a
Yeah.
much more effective balance in all of this. And frankly, I
And
mean, when
yeah.
I travel to Europe, it's very irritating. You sort of open your phone before you get to one step. You're about 20 pop-ups before you go anywhere. So
Right.
it can be quite difficult. It's not really something that I think is in the best interest of anybody, including the user.
Right. So in that context, how what would DPDP rules now do to AI itself, sir? I mean, AI models work differently. They have to kind of we are talking about not using data beyond a point, deleting it, and all of that. So what was the thought process behind it actually supporting development of AI models
You see,
also?
I think you must be honest that at the time when the DPDP Act was originally drafted and framed,
Right.
it predated the India AI mission, although AI was up and running. So
Sure.
to the extent that companies will have to indicate that this will form part of a database which may be used by an AI tool. If
Okay.
they indicate that and people are comfortable with it, then the consent element should take care of it, because this is largely personal data.
Right.
AI also uses a lot of non-personal data. So this is one type of data. To some extent, I think it is also in keeping with the way that we want to regulate AI in terms of how personal data gets used, and that it's adequately anonymized and it doesn't become personally targetable.
Okay.
Is something which we need to look at. But then AI regulation in the country is also evolving, and this framework of the DPDP Act will permit a further evolution of this. Now, for instance, what happens is that companies will probably indicate that there is you should not we will share it anonymized for the purpose of some AI exercise. Now, if that happens and you have consented to it and that data is available and that starts getting used, now there could be possibles, or there could be techno-legal ways in which we can make sure that
Mhm.
re-identification doesn't happen. Those kind of norms can come in due course, and there could be technological ways in which we can address those kind of questions as and when they come up. We don't want to over-regulate ex ante, but we, as always, we keep thinking of ways in which these issues may arise and can be solved in the future.
Right, sir. And the first step would be the data protection board. So how do you see as how soon is immediate? And when will we see this?
No, I mean the fact is that the board has to be in place and all set and ready to go when the act comes into full implementation. So
Right.
we're giving ourselves a runway. We've prepared the digital office, that platform and everything else for the data protection board has been prepared. We are ready to roll it out. So once the appointments etc. are made, then at
Right.
that stage we'll move forward.
And what would be the composition like, sir? How autonomous?
Well, I mean, it's an adjudicatory body. It's not a regulatory body. I think you would have seen that. Their powers are largely those of adjudication in terms of the issues that come up.
Right, right.
And, if there are fines to be levied, penalties to be levied, all those kind of issues.
Sure.
So then they have complete autonomy within that framework.
Right. And so, in terms of a certain rule in the DPDP rules talks about the government's powers also, how it can kind of ask for personal data from the fiduciaries if required. And also, there's been a lot of talk on how have you struck a balance with RTI. So, you'd like to say something about that? So, how is this going
Yeah,
to ensure?
you see, the point is that the government necessarily, there are legitimate use clauses which are there under Section 7. That is there in the original act itself. The rules don't bring in anything new.
Okay.
The legitimate use clauses were there in Section 7 of the Act, and those continue, of course. In addition, the Act itself, at that point, amended certain provisions of the RTI Act. There have been some issues raised around that, saying that it sort of dilutes the provisions of the RTI Act. Our own opinion internally in the ministry is that it does not, because the omnibus provision of public interest is contained in Section 8, subsection 2 of the RTI Act. What got amended is a proviso to one of the clauses under subsection 1 of Section 8. Section 8, 1J had a proviso attached to it, that in certain cases the CPIO or the SPIO could ask for certain data to be provided. Now, the
Okay.
same thing is there in Section 8.2. This seems to have been the outcome of some kind of discussion in Parliament at the time when the RTI Act was passed. And so there was this, in some ways, the proviso to Section 8.1J is almost redundant. And personally, when I read through the whole thing, and if you read it carefully, my feeling is that 8.2 is a much wider provision and can be applied at a much lower level, and that in any case is subject to whatever action the commission, etc., the information commissions, etc., take. So, to
Right.
my view, I don't think it dilutes the RTI provisions in any way. Where there is a public interest, and personal information can also be released. And the original proviso, which was attached to 8.1J, is gone, but then 8.2 is still available, which covers all the provisions of 8.1. So I think it's in that sense a wider power, and it's available, and that is where matters stand.
Right. And in terms of the
And in
fiduciary.
any case, that is an act provision, so the rules can't do much to it.
Yeah, yeah, of course. But also the fact that, the fiduciaries may have to provide data to the government in specific cases. That's also again flowing from the
No,
act as
not from specific cases. Section 7 is legitimate use of personal data.
Rule
And
23 is the powers of
Rule
Rule
20,
23.
there are, you see, those are exceptional cases for law enforcement
Yeah,
agencies, which is always available. No? It's nothing
right,
new.
right, got it. So, and also,
I mean, that's for investigation of crime and those kind of cases. So you can't,
national security in
yeah,
general.
yeah, yeah.
Right. And so, was there a call taken in terms of treating all data as similar? There are some data that is more personal or more critical, like say a healthcare data. Will we see more of those evolve
You
as
see,
you said?
that is there under Section 16.2, that sectoral regulators can take further steps if they so desire for
Okay.
a certain, specific action in those areas. So this provides a minimum standard. And
Right.
it does not take away from anything a sectoral regulator may say. So the health sector regulator may say that there should be higher standards which should be applied to certain kinds of health related information. The financial sector regulator, RBI or SEBI or the insurance regulator or pension fund regulator can say that certain higher standards should apply to data which relate in that sector. So wherever the regulators believe that certain higher standards should be applied, they can. There is nothing that stops them. And this act just lays down a general thing. And we are only talking about personally identifiable data. And
Right.
it varies from person to person, right? I mean, to one person, it may not be important. To another person, it may be important. It also depends on the circumstances. In certain circumstances, it may be important. And in certain other circumstances, it may not be. So
Right.
that varies from person to person. And hence, it depends on how
Sure.
everybody look, each
In
person.
that sense, how much more evolution of these rules? I mean, in the next 18 months or even after that, how do you see in terms of any amendments that will
The
come in?
that I mean, it's too early to say. We've just notified the rules after
Right.
an extensive period of consultation, and there are changes from the draft rules also. So
Mm.
to that extent, we have accommodated all those thoughts. And as far as the actions by regulators in the respective sectors is concerned, that doesn't require an amendment to the rules or anything. They act within the framework of their existing law. That's a flexibility which these rules themselves will provide.
Okay.
Other issues, what arises, we don't know. But at least the issue that you raised with regard to personal information in specific sectors,
Yeah.
that is handleable under this framework itself. It does not require any amendment or change to the rules.
Right, sir. So from here on, sir, what are some specific awareness campaigns or in any other way, how are you hoping to kind of see this
Well,
through?
this is something. I mean, we've done this a bunch of. We've worked on the awareness quite a bit already, and we will work on it further as well. I mean, wherever there's a need, we'll continue to work on it. We'll use this. We'll use this 18-month period to work further on this. So let's see. I mean, I think a fair bit has been done.
Right.
More will be done. This 18-month period is intended for that. It's an ongoing process.
Right. So, and just a few other questions I had. So, in regard to the AI framework itself,
Mhm.
so you've already said in the past that we may not really need amendments to the IT rules, or how do you see that? Do you, in terms of deep fake or any other critical aspects, do you see that there will be some amendments to the law?
No, you see, the point is that we made some amendments to the IT rules
Right.
related to
Rules.
synthetically generated content. So, what I said is, we are not inclined today to legislate and regulate immediately. We don't want to bring in a law tomorrow, right? But we always stand ready. If the risks increase, if there is some reason why a legislation or a change in rule or anything is needed, government stands ready, right? But in today's situation, we believe that innovation should precede the regulation. So, which is why we want to give full scope for innovation to actually work and operate.
Right. So, and so in terms of the India AI mission itself, I mean, when will we see the sovereign or national large language model? Is it a New Year
Hopefully,
gift or is it?
hopefully, let's see. That is what we are keeping our fingers crossed.
Right. So from now, the AI framework guidelines is done, the DPDP rules are done. So till the AI impact summit, so what else? What more is the focus
No,
on?
there are lots of. So the AI Impact Summit is generating a lot of buzz. I'm very happy to share with you that across not just India, but all over the world, people are very interested in the event. We are getting a large number of confirmations from governments, from academic institutions, from leading experts globally, from various companies, other stakeholders. Everyone's very, very excited about the event and very interested in what the event will have to offer. So I think that's been a very good situation that we found ourselves in. And there've been, like I said, we plan to hold about 200 pre-events. We've already held close to 200. And we have applications to hold another 700. So everywhere people are wanting to do this. And it's not just in Delhi, it is all over the country, different parts of the country, and even globally. Events are being held in different countries of the world, not just by Indian missions, but by various other organizations who are keen on hosting such events. And we are doing them in all of these
So the
places.
large language model, we can see the unveiling in the impact summit, sir. Is that the kind of hope or aim?
Let's hope so.
Right. And other than that, sir, anything else you'd like to share on where all this is going, where all this is going to help India in terms of its digital journey?
No, I think there are a number of elements in this. I think as a country, we need to look forward to AI as a technology which we can harness for greater public good. And both the India AI mission and the various other regulatory frameworks that we put in place, which already exist and which we are being adapted for this, will ensure that to a significant extent we are also protected from any potential harms. So the path forward is that on the one hand, we figure out how AI can work for our good, how we develop in each of these spaces in terms of infrastructure, offering the compute, in terms of data sets being available for innovators and for others to build, in terms of models which we have already supported and we are working on. That is one set. Then the other set of things is really applications, and that I think has a huge opportunity for India, both in terms of startups and existing companies, because ultimately AI needs to be rolled out, right? I mean, in different organizations and for various uses, and somebody has to put those applications together and somebody has to actually implement them. And so we believe that's a huge opportunity for India's IT industry and digital industry to actually work towards that. And it will also be a huge opportunity for many of our startups.
Right. Thank you so much, sir. Thank you
Thank
for
you.
making time today.